Court rise. Appeal in the matter of a child.
Yes, good morning.
Good morning, my lord.
Just before we start, can I say in the usual way, we've read the papers. We obviously have focused on submissions. We have a lively understanding of what the issues are. We're also confident that you'll be able to finish by lunchtime. So I hope you share that confidence.
We do.
Fine.
My lord, before I introduce anyone, would it be sensible to say something about confidentiality? This is a matter which relates to a young child.
Yes.
And
Well, I imagine that in relation to that, there should be no report that could possibly lead to the identification of the child in any circumstances. This is being live streamed, but I imagine that you will use the anonymisation that is apparent in the papers.
certainly.
And so far as the local authorities are concerned, would it be prudent in any judgment, Ms Morgan, for the local authorities to be anonymised too, do you think?
My lord, yes, I was about to suggest that it might also, since it is a designation appeal which lends itself to that, if we simply refer to the local authorities as appellant and respondent local authorities.
All right.
It may be necessary to touch on some of the geography, but if we could avoid...
Is that practical? Because surely the geography is absolutely central to all of this.
It may be necessary to touch on some of the geography. It may be possible to do that by distance. I suggested only as an attempt.
Why would it be a problem? Like, of course, the child must not be identified, and therefore the family must not be identified. But why is identification of the geography and of the two local authorities a problem?
I'm not suggesting, my lord, that it's a problem for the local authorities, or indeed a huge problem for the court. I simply cast my eye to what I suppose I might call real life, where somebody perhaps hearing the foster placement where a child is recognises in the supermarket who the family is. And that
Well,
causes
but
vast
Miss Morgan, of course I'm aware, my laws won't be, there's a lot of angst about
Yes.
identification, understandably about identification, and unintentional identification through the identification of local authorities. But this is a case where there's going to be no need to refer, is there, to the facts of to the circumstances which led to the proceedings being started.
I don't see the need to lead to very much of that at all.
And my lord is right, it's quite difficult. I've tried thinking about how to prepare it, how to write a judgment on this, and it's quite instructive to identify the local authorities and indeed the two towns, or maybe that's...
Well,
And I note that, for example, in the recent Ries case, Lady Justice King refers to Leicestershire and Leicester,
Yes.
so...
yes. It's not something I press for,
No.
it's something I suggest. I see that it's not helpful, and so I don't suggest it any
Okay,
further.
all right.
I mean, there are particular geographical conditions which apply in this case. What I'm going to name Grimsby, administratively, that's always been an anomaly for a variety of reasons. For example, as a former presider on the North Eastern Circuit, I was responsible for Grimsby, even though the area around it is part of the Midland Circuit. So I think we have to be, I'm not persuaded that we need to go that far.
Well, I don't press for it, and I sense that I may already be at the edge of my geographical knowledge, so I might be able to assist further even if I wanted.
I wouldn't try swapping stories with my lord on that part of the world this morning.
I won't. My lord, bearing that in mind, may I start by saying that I, as my lord knows, appear for the appellant local authority Lincolnshire County Council, while our friend Miss Porter appears for the respondent North East Lincolnshire Council. Neither parent are represented here today, but the child, through the children's guardian, is represented by Mr. Watterson, who attends and has prepared a position statement, which I hope has reached my lords. It hadn't reached my bundle, but I do have it now.
I don't have that.
No,
I'm afraid.
I don't.
I've had it, but I've forgotten to bring it into court. Shall we?
It may assist my lord to know that perhaps it could be sent electronically, that it expresses itself as taking a neutral position.
Yeah.
So
Yes.
it may be the view that it doesn't need perhaps to hold matters up whilst one gets it
Fine.
without any disrespect to Mr. Watterson. There is also, additionally to the bundle, I hope, as a result of a communication from my Lord Justice Baker's clerk yesterday,
Yes.
3 copies of the
Chat.
Confidentiality.
Thank you very much for doing that.
Not at all.
It seemed to me that was an important part of the building block in the understanding of the law, or might be. And we'd like to know what you say about that when we get
And we received in the same message a communication that the court would invite our respective submissions on how paragraphs 53 and 54 of that decision might or might not factor into the thinking on this situation. Permission, as my lords know, is given by the trial judge, seemingly on the basis of pragmatism, not wishing to import undue and further delay. There are, as my lords know, 5 grounds of appeal set out at page 12 of the appeal bundle, of which I respectfully submit the first has the overarching effect from which the others derive.
Well, history has moved on, hasn't it? Because Ms. Waterston isn't defending the judgment. So the key question is the respondent's notice. Sorry, Ms. Porter. I do apologise. Ms. Porter is not defending the judgment.
Well, my lord, yes, but so far as our appeal is concerned, we respectfully say that we must, with the context of our appeal, say why, the way in which we express our appeal, say why it is that Ms. Porter's respondent's notice, which relies on the parent's move, does not, we say, import ordinary residence of the child.
Absolutely, but the effect of it is that we have to start from scratch. Rather than in the normal circumstance, of course, we're reviewing the judge's decision. But in this case, we're really starting from scratch.
I suppose it will be open to us, notwithstanding the way it's put, to say the judge was right. But you may have got the impression, Miss Morgan, that for my part that isn't
Yes.
likely to be a strong point.
No. Well, my lord, we nevertheless rely on the skeleton lodged by the local authority appellant, for which credit is due to Mr. Anderson, who prepared it.
Yes.
He should have the credit for that. And partly because I know my lords have read it, and partly because we have moved on, as my Lord Justice Arnold says, I don't propose to touch upon much of that which is in our skeleton in argument. What I do say is that it is important to look at the way in which, starting from scratch, the court below should identify how it is that a local authority should be designated in respect of a newborn baby such as this. And I therefore start from the same point, even though matters have moved on. So, my lords, I say the starting point is this, that proceedings are ongoing in the court below are public law proceedings under Section 31 of the Children Act, well known to all, brought in respect of a newborn baby. And I will say it's significant that this is a newborn child and the first child of these parents. I submit also that there is significance to the fact that these were planned care proceedings involving a considerable degree of pre-birth preparation and arising out of the circumstances of the child's parents before his birth.
Yes. Now, we don't, I think, I may have missed something, I don't think we've seen the threshold document. So we don't, and I can't, for my part, get a clear idea of what it was that precipitated the proceedings.
Yes.
I don't think, as I said already, we will need to refer to that in any detail. But is there anything you want to say, just to give us a flavour of what the issues are?
So far as my position is concerned, I am no better informed than my lords in terms of having a threshold document. But I note from the skeleton, the detailed skeleton of Mr. Anderson, that there were serious issues of the ability of the parents to meet the needs of the forthcoming child, that the assessment to be conducted was a PAMS assessment, which, of course, as my lord knows, has to do with the assessment of learning disabled
Yes, well, it's not exclusively for learning disability, but it incorporates tools that provide for the assessment.
Indeed. And that in this case, that is very likely to have been, I interpolate from what I see, a significant factor, because there is also outstanding, as I understand it from both Mr. Anderson's skeleton and Mr. Watson's position statement, there is outstanding an issue of capacity in relation to the parents.
And the official solicitor has been involved.
And the official solicitor has been involved. And
is that all, so far as you're concerned, that all we need to know about the background?
So far as I am concerned, that is all that it's necessary to know about the background, because what it, I suggest, sufficiently gives the court a picture of is a set of proceedings in which nobody appears to suggest that whichever local authority ended up as the designated authority, that there was ever a suggestion this baby was going to move from hospital on birth other than to be looked after by others. That's, as I understand it, the position, and that, I say, is the relevant factor for looking at where matters were.
I don't think it matters, but just on a point of detail, I had understood, and I may have got the wrong end of the stick, that there was a capacity issue with respect to the mother, but not necessarily the father. Is that wrong?
There's nodding from behind, Ms. Poole.
That may well be the position, but I had understood, and I'm sorry to be vague, but I don't have the documents either, I had understood that the PAMS assessment was in relation to both of them.
But that, as I said before, that doesn't necessarily imply that either parent actually has a learning disability. I mean, but anyway, I think the Lord is right. That the capacity issue relates to the mother, not the father.
It may well be that it relates to the mother.
The other, just following on from what you've said so far, the other point is this, is it? If one were to be applying section 31(8)(b),
yes,
is there any dispute that the circumstances in consequence of which the order was made arose in your local authority area, in the other local authority area?
I don't know about that. We say there can't be, but I don't know if there is a dispute as to that.
Right.
So may
Sorry, so you say there can't be any argument about that. It must be them, not you.
I do.
Yeah.
I do say that as to the circumstances.
If B applies.
If B applies.
And if one, particularly if one adopts Lord Justice Thorpe's approach, I forget the exact wording he uses, it's the sort of the principal immediate factors that triggered the proceedings. Those aren't his words, but they're more or less what he says.
Yes. Essentially, the way I would put it is this: is I submit that it's within the area of the other local authority that the circumstances arose,
Yes.
in consequence of which the order is made.
Yes.
The child is born in our local authority, but it's not in consequence of his birth that the proceedings are taken. It's in consequence of the circumstances, and it's only the birth in our local authority that really covers that time period. So that's why I say we submit that here it's 31(8)(b) that applies, and it applies, we say, unarguably, that the circumstances in the other local authority arise. So, my Lord, starting as we are, as my Lord says, from first principles and from scratch, as the court knows, section 31(8) is to be read insofar as there is a need to consider actions by a local authority in providing placement or accommodation for a child, with the interpretation section of the Children Act, section 105, subsection 6. My Lord, in my authorities bundle, that doesn't appear. If it's helpful to have the red book.
Well, it did, but the relevant statutes are. I've got them open in Lord Justice Thorpe's judgment of the Nottinghamshire case at page 4 in the authorities bundle.
So,
I'm sorry, I should have arranged for red books to be provided.
I'm sorry.
Well, we've got that though.
But also section 105 subsection 6 is helpfully set out in Mr Anderson's skeleton argument.
It is, yes.
It is. And so, my lord, when one looks at that section, the disregarded periods are which are relevant for this case, are when a child is in a school or other institution, which arguably a hospital period might be, or C, while he's being provided with accommodation by or on behalf of a local authority, which he is and has been from the moment he left hospital. And so we say that reading those two sections, those two statutory provisions, to borrow a phrase used by Lady Justice King in Re S, that time doesn't count towards ordinary residence. My lords, find that, I don't suggest we turn it up at paragraph 13 of her consideration in Re S. So we say that whether one looks at it from the position of why the learned judge was wrong to do what he did, or from starting from scratch, what the learned judge should have done to be right, we say that this child is a child who does not have ordinary residence. And we say that because the way in which the judge did decide it, which is now not defended, completely disregarded, we say, the statutory provisions that he should have.
Well, he approached it from what he regarded as a pragmatic point of view.
Yes.
Without regard to the statutory test.
Yes. We say that. We say it's not surprising that that's not defended. That's an approach. But the situation of a newborn child such as this, we respectfully submit, is very different from what might have been the case had this child, if one supposes, for example, this had been a child where the pre-birth plan had not been removal at birth, as it plainly was, but for there to be a child to go home to live perhaps with mother, perhaps with father. And in that situation, there had been deteriorating care and proceedings then taken. That would be a different situation. We say there is not scope here for the child to take the ordinary residence of either of his parents.
Well, that was the reason why I suggested the party should look at those passages in Mercury and Chaff.
Yes.
Maybe I'm being a bit too enigmatic, Miss Morgan.
Well, my lord,
why you asked that?
I wondered whether that arose out of the discussion, the lengthy discussion that there had been in Ries in front of Lady Justice King as to matters which were discussed and narrated at length as to, for example, presence and integration, which were then ultimately found.
You're right.
Her.
I was prompted by the alternative ground on which Lady Justice King decided that decision at Ries.
Yes.
And what these passages show, it seems to me, in Mercury and Chaff, is that where a child is looked after for even if for a limited period of time, a newborn infant, by the mother, he or she will acquire the habitual residence of the mother.
Yes.
Habitual and ordinary are synonymous to all intents and purposes.
Well, my lord, I may want to say a little about that in the circumstances in this case.
But in any event, in this case, the point is the child was never looked after by the mother.
Yes, exactly so. Well, my lord, perhaps it's convenient for me to move to the Mercury and Chaff point now in the way that I had understood it to come from my lord, and I may have been wrong about that, I may have been right. It seemed to me that when, and I respectfully submit, when Lady Justice King in Ries, which I say is almost exactly applicable to the circumstances of this case, when she looked at questions of habitual residence and presence, for example, which took up, it seems, I respectfully say, quite a lot of the argument in that case, whilst ultimately being not the basis on which she found it helpful to decide it. If one looks at the questions of habitual residence and ordinary residence, characterised by Mr. Justice Cobb as close relations.
Close relation.
I accept they're close relations.
Very close.
They're not identical twins, though. That's what we say is the important point. And as a general rule, one sees at paragraph 54 of Mercury and Chaff, since it's been raised, it's appropriate that I deal with it. Paragraph 4, we see as a general rule, the environment of a young child is essentially a family environment, determined by the reference persons with whom the child lives, by whom the child is in fact looked after and taken care of. And we say emphasis added to that last part because that is important. Not so here. This child, not in fact looked after, not in fact taken care of by either of the parents.
Yes.
Moving on, if I may, to paragraph 55, where we see in Mercury and Chaff, that is even more true where the child concerned is an infant. An infant necessarily shares the social and family environment of the circle of people on whom he or she is dependent, and consequently, whereas in the main proceedings, and I emphasise this next bit, the infant is in fact looked after by her mother, I pause there to say not so here, it is necessary to assess the mother's integration in her social and family environment. My Lord sees then the paragraph goes on in that regard the test stated.
Well, that's the passage I had in mind.
Yes. And so my submissions on that essentially are these. I accept the generality of that. I say it's inapplicable here. I accept also, as I've said, the characterisation of Mr. Justice Cobb adopted by Lady Justice King, that ordinary residents and habitual residents are close relatives. But here I say that because the child is not looked after by either her mother, his mother or her father, if that test, if that Mercury and Chaff test were the appropriate test to be looking at, it's not the parents to whom one would look to see the social integration. It's not the parents to see who's looking after and taking care of it. It's the foster carers providing him with a home on behalf of the local authority, placed by a local authority. And therefore, that brings one, I respectfully submit, full circle back to 105.6, because that is a disregard. And I pause there to take up, if I may, the identical twins point that I make, because I don't make that flippantly. Habitual residence, well established, my Lord, as being not something defined in statute, but a question of fact and determined fact specifically in each case where the need arises. Ordinary residence, which is what the court is considering here, is to a degree similarly not defined. At least it's not defined as to what it is, but it is defined as to what it isn't. And I say that where statute goes to the trouble defining what it's not time spent placed in accommodation provided for on behalf of the local authority. That cuts off determining ordinary residence for this child or any child on the sort of Mercury and Chaff basis that would be applicable to its fraternal twin, perhaps. So that's the submission that I make on that. It's important, I acknowledge, to consider and perhaps to draw the analogy with the question of presence discussed at length in Ries, in case that feeds into the Mercury and Chaff consideration of habitual residence arguments, which I say, for the reasons I've just said, are wrong. What I say effectively is that the disregard that applies in relation to ordinary residence has the same meaning, effectively, as the child not being present, if one looks at it through that lens. But I say that's the wrong lens anyway.
Okay. So ordinary residence is a narrower concept than habitual residence.
Yes.
Because it's restricted by statute.
I'm not sure that I necessarily say it's a narrower concept, but it is a more strictly defined concept for the purpose. Because the reason I say that is that for the purpose of designation, it's ordinary residence that is specified. And Parliament could have said habitual, could have said usual, could have said anything, but said ordinary. And it's also, I say, important that it's more strictly defined, that section 105.6 in the interpretation section is expressly directed to interpretation of ordinary residence for any purpose under the 1989 Act, which is perhaps a different purpose than one sometimes is looking for habitual residence in the wider reduction sense. And so I say, since the purpose in section 31.8 is designation, and 105.6 I expressly says for any purpose that's to be used, it's not open to try to, as we would have said the judge did, step around the disregards, or to do it in the Mercury and Chaff way if one's starting from first principles. So that's essentially the submission I make about ordinary residence as distinct from habitual residence. Different creature, different rules, different purpose is essentially what I say. For all of those reasons, that is why I respectfully submit that although I understand why the first respondent makes the submission at paragraph 14 of the skeleton, page 56 of the bundle, about the parents moving, and that is said by the first respondent to be an important consideration when looking at designation, that the mother and father moved to Skegness, as we're now saying out loud. They say that the tenancy was understood to be signed before birth. Mother stayed overnight with some members of her family and then commenced the process of moving after. Father signed a year's contract for work at a pub sometime like the 9th to the 11th of July, child being born on the 8th. We respectfully say that, as it happens, although, as my lords will have seen in Mr. Anderson's skeleton, we say there were different reasons for the parents moving. I say that for all of the matters I've touched on in relation to ordinary residence, it doesn't matter why they moved, because this child does not take their ordinary residence.
Because she never lived in their care.
Because the child never lived in their care, was never looked after by them.
Yeah.
And we say it would be a stretch of artificiality too far to be able to even begin to argue that, for example, contact arrangements were sufficient to be made in their care.
You really say this case comes in the second, the alternative reason Lady Justice King gave in paragraph 49 of her judgment in the ES, paragraph 77. She talks first of all about presence.
She does.
Page 77 of the bundle. Then she says, paragraph 49.
Yeah.
If I'm wrong and presence is not an essential ingredient, I'm nevertheless of the view that where circumstances arise where there has not only been no presence, but also that the baby in question has never lived with the parent.
Yes.
Through whom ordinary residence is asserted, that cannot be a basis upon which to make the finding.
Yes.
It follows
Precisely.
the mother's.
Precisely what I say. And I also say...
So is that, sorry to interrupt you, is that why you say, I think you said a little earlier, this case is very close to S?
Yes, I do.
And that's
I say
a particular link you make?
It is. It's a particular point I make. I say that there are aspects of this case where one could almost change the names. I also say, and it's an important point for me to deal with, that whereas in contradistinction to what I say in reliance upon 49 and 50 of Re S, where the respondents rely in their skeleton, quoting from the head note of Plymouth and C 2000, and I accept that in other circumstances this would be right, where there is quotation that the newborn baby was incapable of having an ordinary residence apart from the mother, and therefore the ordinary residence would be dependent on the mother. That was a case where, as appears in the recitation of the facts, if my lord go forward from the head note to page 876, which I think is page 14 of the authorities bundle, that was a case where the child and the mother went together from hospital to live first of all with a mother and baby foster care replacement and then at a residential unit. And so in that case, the child was cared for by the mother, and that's factually distinguishable, we respectfully say, from the situation here and the situation which Lady Justice King was considering in Re S in 2017. And so when I go back to the dialogue I was having with my Lord Justice Baker a moment or two ago, where in Mercredi and Chaff, setting aside for a moment the fact I say it's inapplicable, that specifically recognises that what is important factually there is by whom the child is in fact looked after, and where the infant in paragraph 55 is in fact looked after by her mother. And I say same clearly applied in the Plymouth case, doesn't apply in this, didn't apply in Re S. So I respectfully say that those matters are the ones on which the court should decide ordinary residence of this child, whether this court is an appellate court or the other court is a first instance court. There are matters of convenience which were prevalent in the first instance judge's judgment and feature at length in our skeleton. And since one starts from scratch, I don't propose to address those at length, save to say this, because...
How does one get into convenience? It's not part of the statutory test, is it?
well that is what I say. I also say that it also falls into the same impermissible ground that came in a slightly different guise in the Northamptonshire and Islington case. In Northamptonshire and Islington, the judge was completely upfront with the fact that he was bending over backwards to designate Northamptonshire because of the shockingly appalling behaviour of Islington. He says as much in the judgment. I don't suggest that there's that sort of thing going on here at all, but for exactly the same reasons that my Lord Justice Arnold has just identified. Doesn't fall within the statutory provisions, wasn't permissible. So
I mean, there's a good reason why it's not, isn't it? Because otherwise, local authorities will be arguing as to which authority found it more or less convenient or inconvenient.
Yes,
and you can imagine the disputes going on forever.
I take head on the gentle and politely expressed disappointment from Mr. Watson, echoing the slightly less gentle disappointment of Lord Justice Thorpe in the past that this is being litigated at all, but it is. And were the convenience argument permissible, then, my Lord, I venture to suggest it would be litigated every single time there was a chance of it, because why wouldn't it be? So I don't propose to deal further with convenience unless it's thought that I need to.
Well, it's to avoid those arguments that Parliament has put forward what's intended to be a straightforward statutory test.
Yes.
So it's not as straightforward as Parliament hoped.
It may not be as straightforward as Parliament hoped, my Lord, as is obvious from the jurisprudence, but I say it's perfectly straightforward for this case and can lead to only one outcome. I don't want to, bearing in mind the short adjournment endpoint, I don't want to address things that I don't need to. Is there anything else that I need to address at this stage?
Not from me. Not from any of us.
Thank you.
Thank you very much. Yes, Miss Porter.
My Lord, yes. On behalf of North East Lincoln Council, you will have seen from the skeleton argument that the respondent local authority doesn't seek to say that the decision made by the lower court is done on the correct basis.
Yeah, that's very, if I may say so, Miss Porter, that's very helpful to us, and you will have gathered from our interchanges with Miss Morgan, we also think it's completely right that that concession was made, but that still doesn't mean that concessions are made even when they should be made. So we agree that the judge, for perfectly understandable reasons perhaps, approached it on a convenience, pragmatic stance, or what he thought was pragmatic, but was clearly not right in principle.
I'm grateful, my Lord. And certainly, starting from the principle of looking at the matter from scratch, I can confirm on behalf of the respondent local authority that it is agreed that in the event that the court isn't satisfied that section 31(8)(a) is applicable in this matter, then the consideration in relation to designation must then fall to 31(8)(b). So that's a matter that's accepted on behalf of the respondent local authority. But when turning to
Sorry, can I be clear about that?
Yes.
Are you accepting that the circumstances under 31(8)(b) arose in your local authority's area?
My Lord, that's correct, yes.
Thank you.
So just so that I've got a proper note, so from that point of view, as far as your client is concerned, it's 31(8)(a) or bust.
My Lord, that's correct, yes.
If I may put it that way.
I'm grateful, yes.
Thank you.
And my Lord, in relation to the consideration of 31(8)(a), again, the respondent local authority accepts the section 105(6) disregard in relation to periods of placement. But what the respondent local authority does say is that when considering the question of ordinary residence of this child, it is relevant that this child was born in the hospital in the appellant local authorities area. And it is also said that it is relevant that there was one day before the child was placed with the family members as arranged by the local authority. And the reason the respondent local authority says that, my lords, is that when considering the matter in Re S, Lady Justice King does spend a lot of time considering ordinary residents, and I will come to various parts of the judgment shortly. But it's argued on behalf of the respondent local authority that rather than a hospital being an institution as set out in section 1056, it is a period of time, albeit a very short period of time, during which the mother cared for the child prior to the order being made and the child removed. My lords, it's said on behalf of the respondent local authority that until the point at which there was an order made, the decision making in relation to the care of that child rested with the mother, who was the sole holder of parental responsibility at that time. And so, bearing in mind that, my lords, it's argued that if it's accepted by the court that section 1056 doesn't come into play until the child is accommodated by the local authority, and that being with the family members in this case, looking at ordinary residence for a newborn child then becomes important. And my lords, it's been said on behalf of the appellant local authority that Plymouth County Council case, as set out in the skeleton argument, should be disregarded as something that can be relied upon by the respondent local authority for the fact that the child, after coming out of hospital, was placed in a parent and child placement with the mother, and then subsequently a residential placement. But my lords, it's argued on behalf of the respondent local authority that indeed would come under section 1056 as a disregarded placement as a result of both of those placements being accommodation provided by a local authority, albeit with the continued care of the mother. And in fact, my lords, if considering section 1056, the example given of an institution is a school, and it's argued on behalf of the respondent local authority that in hospital, albeit a provision of a service, of the medical service, the mother remained in that placement with that child and cared for that child, albeit with the assistance of medical professionals, but putting it apart from an institution such as school, where a child wouldn't be cared for by a parent.
In this case, did the parents agree to the care order?
My lord, I understand the mother didn't have capacity in the previous set of proceedings, so I think it was taken on the basis of concerns of capacity that she wouldn't have been able to agree.
But so was the care order contested? Care order?
My lord, if I may have 1 second. My lord, I'm afraid I'm not going to be able to assist the court in relation to that.
No, but as I understand it, maybe I should ask a slightly different question. The parents were involved in the planning of what should happen after birth.
They were.
They put forward, and they were subject to the assessments. They put forward these family members and a number of family members for viability assessments. Is that right?
My lord, they did, yes.
And it was always understood by the parents that the child would be removed very shortly after birth.
My lord, I think that's correct. Certainly, the parents were aware that that was the plan.
And that's why they moved to Skegness.
My lord, yes.
They wanted to be close to where the child was going to be with the relatives.
My lord, yes. And on the chronology, the parents moved to Skegness a few days before the birth and actually lived with the family members up until the point of the birth, notwithstanding having a flat and the tenancy agreement, so they could have the assistance of the family members.
Don't those circumstances, Ms. Porter, affect the evaluation of whether the child acquired the mother's ordinary residence in the few hours in hospital?
Well, my lord, it's argued on behalf of the respondent local authority, no, it doesn't. Certainly in terms of the decision-making around the child prior to the interim care order, that rests with the mother, who has parental responsibility. whilst not having litigation capacity, it hasn't been assessed that she lacks capacity in any other way. So, my lord, in terms of the ordinary residence, it's argued on behalf of the respondent local authority that the mother had moved to that area, knowing that that is where the child will be, and making the decision that she wished the child to be born in that hospital and to live in that area, and albeit with the family members.
Sorry, can I just ask a question? You referred to the mother's lack of litigation capacity, and I of course understand what you mean by that. But, and this may be a question that no one knows the answer to, but have any deputies been appointed?
My lord, as understood, the official solicitor has been appointed as litigation friends for the mother within the care proceedings, but I'm not aware whether or not anything has happened outside of the proceedings. My understanding was that the only assessment in relation to capacity was in relation to litigation capacity, and that as far as I'm aware, there's been no consideration as to whether or not the mother would need assistance of a deputy, or having had her case being brought before court of protection. She certainly hasn't been accommodated by any other means. She has been living independently, albeit between her family and the father.
Okay, so your understanding is that there's no deputy either for finance and property or for welfare?
My lord, that's correct, yes.
Thank you.
So, my lord, in
I
relation...
think Miss Porter there was nodding from behind you. I just did. So you got that right.
I did, thank you, my lord. So, my lord, in terms of looking at the issue of ordinary residence in such a short period of time, and it is accepted it is a short period of time, I then come on to the submissions made on behalf of the appellant local authority in relation to ordinary residence being identified specifically in the statute when looking at the period of disregard under section 105. And my lords, what I would say is that when looking at ordinary residence and looking at the issue specifically as to designation of local authority, in Lord Justice Thorpe's three guidance notes that were provided in the Northamptonshire County Council case that I referred to at paragraph 12 of the skeleton argument, Mr. Justice Thorpe set out there what should be considered in relation to designated authority, and confirmed at the first section that the judge's function is to carry out a rapid and not over-sophisticated review of the history. But importantly, I submit on the second category, he says the subsection should be given the construction that achieves the result for which it's designed, namely a simple mechanism to determine the question of administration. So, my lords, the reason I draw that to the court's attention is when looking at the question of ordinary residence, and specifically looking at its use in relation to designation, it's argued on behalf of the respondent local authority that if ordinary residence were considered in terms of the short period of time when a newborn child is cared for by a parent with assistance in hospital, it would enable, when looking at presence, the court to undertake that analysis of the very simple mechanism to achieve the question that is being asked of the court, and that is to consider which of the local authorities is best placed to administratively assist in relation to the care plan for the child. So, my lords, that is why I say that presence is so important. And when coming on to the question of presence, my lord, you've already been addressed in relation to the Meckredy and Chaff case, and looking specifically at the care or the time that the child stays with the mother. And I say on behalf of the respondent local authority that once it's established that the mother is caring for the child, albeit for a number of hours or for one day, it then triggers the consideration of the court, because of the exercise it needs to take in relation to designation, to then look at the habitual residence of the mother.
So if, let us say that instead of going to Skegness, the mother, in the way that she did, the mother had gone to London and given birth to the baby in, say, the London hospital,
Yes.
and the child had then been removed the next day, the same time period.
Yes.
Nonetheless, the mother having been in Tower Hamlets at the time the child was born, the child would require ordinary residence in Tower Hamlets?
My lord, no. The reason I say that that would be different is that in this case we have a clear decision by both the mother and the father to enter into a tenancy agreement. So not a short arrangement, not a short travel with the intention of then leaving. We have the parents making that decision to live there. We have the father's decision to take the year contract of employment. So that's where I say that it becomes important to look at the situation around both of the parents, albeit with them knowing that the child would likely be placed with the family members. The parents have made the conscious decision to move to that area prior to the birth, making arrangements for them to remain in that area post-birth.
Okay.
And
So that's how they've acquired habitual residence.
Yes, my lord. And then the baby has acquired ordinary residence by virtue of either or both being present in that
But
area.
if applying my analogy, my alternative example, extending it, the parents had made a plan to take a tenancy in Limehouse or wherever, and had moved there shortly before the baby was born, without telling the local authority, and then had the baby then been born in the London hospital, that would have been sufficient to vest Tower Hamlets with as designated local authority, would it?
My lord, I would say on the basis of the question of ordinary residence, if it's accepted by the court that the baby would acquire that ordinary residence at that point, then I would say yes.
So the crucial question, therefore, is whether you're right in saying that the fact that the child was looked after for a few hours or was with the mother for a few hours in hospital, whether that's looked after is perhaps the issue, with the mother for a few hours in hospital, is sufficient to mean that she acquires the mother's ordinary residence.
My lord, yes. And then I think it moves on to the consideration of Lady Justice King and Ries in relation to presence. And paragraph, I think in the Appellant Local Authorities skeleton argument, they rely on paragraph 50 of Lady Justice King's judgment, where she speaks about this case as one of those rare cases where the child in question, having been removed from his parents at birth, has no ordinary residence. But I would also refer your lordships to the previous paragraph, paragraph 49, which I think is important to read alongside paragraph 50. In that paragraph, Lady Justice King says that in her judgment, again, she repeats the rare cases of no ordinary residence, but she then goes on to look at the majority view of the Supreme Court in A&A and also the matter of Mercredi and Chaff. And she relies there on her analysis in relation to presence. And, my lords, that's why I say that consideration is presence is important and actually distinguishes Ries in relation to this case.
Spell out what precisely do you mean by that?
My lords, yes, in relation to Ries in itself, the child in that case hadn't been born in the area. And my lord, what Lady Justice King considers in that judgment is looking at the presence and how important that is when then going on to look at the ordinary residence. And so, my lord, I say that in relation to presence, we have in this case the presence of the child in the Appellant Local Authorities area, albeit for a short period of time, again, before the disregard period set out by Section 105. But when we go back to looking at Thorpe J's guidance in relation to designation, again looking at the second point and looking at the administration, we can see that presence becomes important when considering what area is going to be best to be able to administer the Interim Care Order, but also, importantly, looking at the presence of the child in the hospital with the mother suggests that ordinary residence can flow more freely when looking at that of the mother. So it's the two.
Well, presence may be necessary to acquire ordinary residence, but it's not sufficient, is it?
My lord, it's not sufficient, but I say that the court could then go on, bearing in mind that this is a newborn baby, to look at that presence alongside the mother's ordinary residence, which I say has changed to the appellate local authorities area at the point pre-birth, which is the importance in this case.
But in this point, although the facts aren't identical, on this point they are on all fours, aren't they? These two cases, Ries and this case, and Lady Justice King is saying that where a child is removed in these circumstances, she hasn't lived with the mother, and therefore doesn't acquire the mother's ordinary residence.
My lord,
Isn't that what she's saying here?
My lord, but then I come back to the matter in Plymouth County Council, looking at the care afforded to the child, so that the mother had the care in the hospital, but then after that had the care in institution, or in the care in a placement provided by the local authority. So I say that it's not as simple as saying that if a child has been removed from birth, then ordinary residence, or the child would simply not have ordinary residence. It doesn't fit with the suggestion that that's a rare case. Unfortunately, it isn't a rare case that a child is removed at birth. And so, my lord, I say that it's not as simple as saying, as a child has been removed directly from hospital, there isn't ordinary residence at that point, that you don't look at the mother.
But in Ries, the Leicester case, the child was in hospital for a day before being removed. So it's the same. Well,
my lord, it was a hospital outside of the designated authorities area. That's the distinguishing fact, I would say, in relation to Ries. So in Ries, my lord, the mother had moved to the designated area. The child had not. The child hadn't had presence in that designated area. The child had been born outside. So I say that is the difference between this matter and Ries.
Isn't the potential artificiality with all of this that the mother was only in the appellant area because that's what you, doubtless for very good reasons, had decided? You had chosen, as I say, doubtless for very good reasons, the most viable carers, and they didn't live in Grimsby, they lived in Skegness.
My lord, certainly when looking at that, it's important to note, I would say, that these are family members, and when considering ordinary residence, and certainly Mercredi and Chaff, the paragraphs that have been referred to, one of the considerations is the family network within that area. And so, notwithstanding the fact that family members are now providing the accommodation by the local authority, it's important when looking at ordinary residence, this isn't an area in which the parents have simply moved to get away. This is an area that the parents have moved to near family, albeit knowing that that was the proposed placement for the child. But when looking at the ordinary residence test and looking at the family environment, it's submitted that actually that is something that is relevant when coming to that determination. It's not simply an area that the parents have chosen. They do have connection to that area.
Yeah.
Just going back to your distinction, your basis for distinguishing the two cases, Ries and this case. In that case, the family moved to Leicestershire, to the county,
Yes.
as it were, to get away.
Yes.
But the child was born in Leicester, back in Leicester.
Yes.
So there, the child not only was never present in Leicestershire,
Yes.
that's the difference.
My lord.
You say.
Yes.
But that's not what Lady Justice King says, is it? Because she says if we ignore, leaving aside paragraph 49, if I am wrong and presence is not an essential ingredient, ordinary residence to be established, I'm nevertheless of the view that where circumstances arise where there has not only been no presence, but also that the baby in question has never lived with the parent, through whom ordinary residence, that cannot be a basis upon which to make the finding that the ordinary resident follows that of his or her mother. The presence point isn't, is it, essential for an essential part of that reasoning?
Well, my lord, in relation to whether or not it is essential, certainly there is a disagreement, and Lady Justice King speaks at paragraph 44 in relation to that. She says that in my judgment, the requirement of physical presence must equally apply to a determination of ordinary residence. She then says the majority of the Court of Appeal in A&A was robust in suggesting that presence may be an absolute requirement. The Supreme Court do not specifically deal with this issue. So, my lord, I say in terms of the analysis that Lady Justice King made in relation to the situation for the requirement of presence, she has outlined there that there isn't a consistent approach in relation to that.
But the child was never ordinarily resident in your local authority.
My lord, no.
Because of the presence point.
Yes.
But that doesn't mean that she acquired an ordinary residence in the other authority.
Well, my lord, I say as a result of presence, it then enables the court to consider, or the court should consider, whether the short period of time prior to the interim care order, the period of time during which the mother had sole parental responsibility and the care, albeit assisted, in the hospital, I say that's when that should be considered in terms
So you say that short period of presence, plus the fact that she's with the mother,
yes,
next to the mother, presumably in the cot next to the mother,
yes,
that's sufficient to give the child ordinary residence. That presence and short period together for a few hours.
my lord, yes.
Thank you.
So that's the nub of it, really,
My lord, it is.
because that's the 31(8)(a) point.
It is, my lord.
And if you're wrong on that, if you don't accept that argument, then 31(8)(b) applies, and that's that.
My lord, necessarily it does, yes. Yes. And my lord, again, I would say that Plymouth County Council case is a good example of looking at when it is considered that a parent cares for a child. Certainly in that case, I would say that the mother caring for the child in the mother and baby placement and the residential unit, both situations where the child has been provided with accommodation by the local authority, albeit with the mother, would be a disregard period. And so in that case, we can see that the mother had a similar period of limited care of the child in hospital before she was placed there. And in that case, it was then said that a newborn baby was incapable of having ordinary residence apart from the mother. So I say that that supports the argument that we then move away from looking at the baby and then look at the mother's ordinary residence, which we say had changed to that of the appellant local authority prior to birth. So, my lord, I don't propose to address you in relation to the issue of convenience unless I can be of any assistance. But
Well, I think, do you agree with Miss Morgan that it's irrelevant for the purposes of the statutory test which we have to apply?
my lord, I do.
Yeah. Well, you both agree about that, so we don't need you to address that. Thank you very much. Is there anything else, Miss Porter, that you want to?
I think you're instructing solicitor.
Oh,
Excuse me.
there is something else.
Oh, maybe.
My lord, it's simply to confirm that the placement of the child with the family members was agreed on behalf of the parents at the first hearing.
Yeah.
Yes.
Yes, thank you very much. So, can I just ask this? The relative, just so I know, the the couple they're with, the woman is a relative of the mother, is that right?
Yes, that's correct.
How close a relative? Or does it not matter? It doesn't matter.
My lord, I think she is a stepsister of the mother, so
Thank you.
fairly closely related.
And is this a case where special guardianship is being considered?
My lord, I understand, yes, it is.
Yes, thank you very much, Ms. Porter. Mr. Watson, in relation to the position of the guardian, Ms. Morgan told us that her understanding is that the guardian is neutral as to this debate. Is that right?
Yes, my lord, I have the luxury of having instructions on the neutral case and also knowing something of the geography.
Say again?
Also knowing something of the geography of
Right.
the area. But yes, I apologise that some of my lords didn't receive the position statement, but essentially the guardian took a neutral position in the court below. He maintains that position. The main thrust of his wider position was alluded to by the appendant local authority in relation to the dispiriting position that sometimes we find ourselves in with these matters having to be litigated. But as my lords have already noted, a clarity or a hope for clarity in relation to a test doesn't always lead to clear decisions being taken
No.
on the ground.
Well, we understand that. And the important point to note is that this isn't a case like Northamptonshire and Islington where there are allegations being made of a poor service being provided by one or other of these local authorities. That is not this case. Essentially, bluntly, this is a dispute about money, about who's going to have the financial burden of this.
Quite.
And one understands the pressures on local authorities are such that from time to time these things can't be agreed and have to be determined by the court. So it's
Agreed,
not a
totally.
criticism of anybody.
No.
All right, well, thank you very much.
Well, could I just ask one question?
Yes.
I'm sure you're going to tell me that you can't answer my question, just in case you can shed light. As you've heard, Ms. Porter relies strongly upon the few hours of care of the child by the mother in hospital.
Yes.
Are you able to enlighten us at all as to the factual circumstances pertaining to that period of time?
I'm afraid, my lord, I'm not.
I rather thought that would be the case, but thank you for bearing with my question.
Thank you.
I do have one question, possibly from Ms. Porter, which is not for him, though.
Right, all right. Well, Mr. Watson, thank you very much. Before we hear from Miss Morgan in reply, Miss Porter, I think my Lord Justice Baker has a question.
Having said there's no criticism of either local authority, how much notice did your local authority give to Lincolnshire
My lord,
of this imminent move?
My lord, in the chronology provided...
There's reference to an email a couple of days before.
My
Is
lord,
that right?
I think that's correct. As far as I'm aware, the tenancy agreement was signed by the parents, and it was at that point that the local authority notified Lincoln, and I think that transpired to be around 2 days before baby was born.
But it was known for some time, wasn't it, before that the child was likely to be placed in Skegness?
My lord, yes, but I think the difference was that the parents had actually moved to that area at that time, and that's what triggered the email from the respondent local authority to the appellant local authority, as opposed to looking at the potential for placement, which is accepted is disregarded. The fact that the parents had signed the tenancy agreement signalling their intention to move and their move date, it was at that point the local authority notified the appellant local authority
So,
of the move.
had they not done that, your position was this would have been this was our case and would have stayed our case?
My lord, yes.
Thank you.
Give me, my lord, if it assists, the viability assessment of the carers was signed off on the 24th of June.
So it was only a couple of weeks before.
Yes. Yes, Miss Porter. Sorry, Miss Morgan.
My lord, there's little that I would wish to say in reply. It is indeed, and I think the chronology is accepted expressly, 5:20 to 5 on the 6th that the email comes saying, I'd like to transfer a case to your area, please. And the baby was born on the 8th by an induced birth.
Yes. For my part, do you have anything to say about Miss Porter's point on the Plymouth case?
My lord, I say two things about that, I suppose. First of all, I say the time in hospital is insufficient for all of the same sorts of reasons that I had started to say to my lord, that, for example, caring for a child in contact would be insufficient for caring for. The other thing that I say about the Plymouth case is that the important point about the Plymouth case is that it is the mother who is with the child, caring for the child in that case. And when one looks at 1056A and A, which I say is an institution, I stand by that, and C, that speaks of where the child is placed. And I say it's the mother's presence that makes the distinction that I alluded to earlier in relation to Plymouth. I say the presence of the mother for what are plainly hours, weeks, days in that case makes the difference. I don't accept at all that what may or may not have been the hours in the hospital as to which I fully accept none of us have evidence as to what actually the mother was doing by way of caring, but I say that in circumstances where there is a planned removal, a known removal at birth, an induced birth, and a long lead up of planning of assessment of, as I understand it, 3 possible viable family placements, of whom the best happens to be this one. That is, I say, insufficient to found.
Well, the local authority would have had its application ready.
Yes.
The respondents would have their application ready to go to court. And they might have gone on the same day, when the baby was born, or the next day.
Maybe not.
And there we are.
Yes, but I say that the Plymouth situation, I say, is different because of the continuing presence of the mother throughout. If one reads that decision at the factual recitation at page 876, that is clearly a period of weeks where that child is being cared for by the mother, at least in the positive placement, and the likelihood is a usual 12-week placement in the unit. But yes. Beyond that, there's nothing that I would expressly wish to respond to. I'm afraid I am not attended today, but I have not seen anything coming through that I've missed, so I think I'm going to take it that there isn't anything that I have, unless there's anything I can assist with further.
No, thank you very much, Miss Morgan. We will rise and consider effectively, logistically, what we do and the timetable over which we do it. So we won't be very long, so don't go away. Miss Morgan, Miss Porter, we want to give judgment in this case, and we want to do that today. Is it fantastically inconvenient if we said to you both, can you be here back in court at 3 o'clock for judgment?
My lord, that's
Is that all right? Mr. Watterson, as far as you're concerned, you're very welcome to attend.
Yes.
That will be a judgment. It will be an extemporary judgment, so it will take a bit of time, but it is not compulsory.
Yes.
But that, therefore, is what we will do. So we will adjourn now and give judgment at 3 o'clock this afternoon. And we apologise for any inconvenience, but I'm sure you understand that certainly during vacation, the desire not to have more judgments hanging over one's head than is strictly necessary is a good thing. And since between the two of you, you've been able to identify a number of relatively short points, we will give judgment later today. Thank you very much.